Good evening to everybody. I am Lian Buan, a Rappler's Justice Reporter. This is a very special episode of Love the Land podcast. We are broadcast simultaneously on Facebook and on Twitter Space. So today is the 49th anniversary of the martial law of the dictator Ferdinand Marcos. And during that time, there were 70,000 Filipinos detained, 34,000 tortured, 3,240 were victims of enforced disappearances. 75,000 people have filed claims before the Human Rights Victims Claims Board, and so far 11,000 claims have been successful. These are facts, both historical and legal, yet some people still choose to deny that these atrocities happened during that time. So how can we ensure that we hashtag never forget? So that is the topic for tonight, and I've invited the lawyers that you see on our screen. Attorney Ros Togade is a fellow of Center for International Law. She's a senior lecturer at the UP College of Law. Attorney Rafael Apa Pangalangan is also a fellow of Center Law and a senior lecturer of UP Law also. And Attorney Jemo Fernandez, a doctoral candidate and sessional academic at the Australian National University. At sabi nila magkakaklase daw sila sa UP Law. So, Barkada get together. But they're here because they wrote the very brilliant paper, Marcosian Atrocities, the Legal Constraints on Forgetting. It was published in 2018 on the Asia Pacific Journal on Human Rights and the Law. So, guys, we'll get to it. Your proposal is to enact a memory law. Ano ba yung memory law? Can you describe it briefly to the viewers and listeners? At what does this proposed law entail?
Yeah, sure. Great question, Leanne. Great way to start this conversation. So what we propose is a memory law, which is pretty much any law that governs the recognition or interpretation of a historical event. And what makes memory laws such a unique topic is how it captures that dilemma, which portrays that dual role of the state, which is both the protector of human rights and likewise the primary violator of human rights. And that's something that is put front and center when it comes to memory laws, because what is otherwise a limitation of human rights may actually be justified vis-a-vis other pursuits of justice, such as the right to truth, which we highlight in our paper. So what would this law entail? It would entail possibly the recognition of a fact or the delimitation of the possible opinions that we may express vis-a-vis a fact. And what that law regulates would determine what legal hurdles it would need to satisfy as well.
Apa, am I correct? May memory law sa Europe, diba?
Yes, so we have memory laws across the globe. The most famous ones refer to Holocaust denial. So that is the Nazi crimes, and again, it has been brought before various domestic judicial mechanisms as well as regional mechanisms, particularly the European Court of Human Rights, and in Germany in particular through what is referred to as the Auschwitz-Lie case. It involved a domestic law of Germany, which not only prohibited the denial, but criminalized the denial and the revisionism of mass atrocities at the hands of Nazi Germany.
Thank you. Siyempre, diba, if you criminalize, for example, denial or yung not acknowledging the truth of atrocity, siyempre meron yung press freedom implications. But we'll go that medyo maya-maya. What I want to do next is let us walk through the people listening now and watching now. It's some kind of a legal look back kung ano ba yung jurisprudence and laws that happened after martial law. So let's begin with the 1987 Constitution. Wouldn't you say that this was the first piece of legislation that recognized the atrocities of martial law? And while when you read it, hindi naman siya in a black and white na we recognize the atrocities of martial law. But you pointed out in your paper that it was one of the remarks during the CONCOM that was one of the purpose of the Constitution. Anyone?
Well, not necessarily about the 1987 Constitution being the first instrument to recognized Marcosian atrocities. Remember, there's the 1986 Freedom Constitution, which, among others, recognized the need to restore democracy, protect basic rights, rebuild confidence in the government, and eradicate graft and corruption, among others, as a response to the
Mm.
experiences during the term of Mr. Marcos. Second, there's Executive Order Number 1, Series 1986,
Mm.
so that created the Philippine Commission on Good Governance to recover the ill-gotten wealth, the Marcoses, and investigate cases of graft and corruption. And then there's the 1987 Constitution. If you review the current Constitution and the debates during its drafting, many of its provisions were actually crafted with the aim of avoiding the rise of another Marcos. First, it limited the prerogatives of the president and strengthened the other branches of the government. Ano to, no? It cut back on the president's power to impose martial law by imposing instances in which the power may be used and thereby subjecting it to the review of Congress and the judiciary. Second, it granted broader powers of oversight to the other branches of the government. So Congress can now possess that prerogative to limit the use of discretionary funds and inquire into the contracting of foreign debts, again, because of the experiences
Mm.
during the martial law era. And then finally, other measures involved measures against the abuses of power committed during the Marcos regime. Considering the regime's gross violation of fundamental liberties, the
Mm.
Constitution created the Commission on Human Rights,
Yeah.
which has the power to investigate all forms of violations of human rights and provide appropriate measures for their protection. And then finally, given the widespread corruption under Mr. Marcos, the Constitution also created the independent office of the Ombudsman, enjoying fiscal economy, removable only by impeachment, and has the power to investigate and prosecute cases of graft and corruption.
Yeah, if I
Thank,
may
thank you.
add to
Yes, go,
if I may
Ross.
add to Gemo's observations, no, it was quite remarkable that in the opening session of the Constitutional Commission of 1986, Justice Cecilia Munoz Palma, during her acceptance speech, no, as president of the CONCOM, said that the aim of the drafter should be to draft a basic law that serves all the Filipino people and to respect human dignity, protect basic freedoms, which we could interpret now contemporarily as a repudiation of the legal order that that prevailed during martial law, which is the exact opposite of having human rights and basic civil liberties curtailed.
At saka after the passage of the Constitution, the Supreme Court after that, parang decided cases that eventually got rid of yung aso, no? Na sinasabi ng mga ibang petitioner ng anti-terror law na parang binabalik ng anti-terror law. But more on that, thanks Gemma for mentioning yung EO1 ni Cory Aquino, which created the PCGG with the primary task of going after and recovering Marcos's ill-gotten wealth. We know that PCGG exists today, pero ang dami niya nang natalong kaso sa Sandigan Bayan. And I think the last few years, sunod-sunod yung mga pagkatalo na yan. Would you say that every time may natatalo, every time we post on the newspaper, on our headlines that PCGG loses another civil case against Marcoses, ganyan, would you say that those losses have in a way, parang hindi siya nakatulong sa pagpigil sana sa historical revisionism?
You know, it's interesting you mentioned that, Lian, because just before this spaces started, no, what I assume would be an internet troll was trying to argue with me on Twitter and posting all these links of what you just mentioned, no, cases where the PCGG lost and stating wala namang inaresto. So why would I believe you when you claim that the Marcoses have indeed stolen all of this money? No, despite the fact that the Supreme Court has ruled time and again that there was a great pilfering of and plundering of the public coffers during the martial law era. No, so I think that is a valid concern that all these cases where the Republic loses, no, every time the Republic loses in a civil case, um, that was spearheaded by the PCGG, it chips away, I think, and it is a valid concern that the legacy of economic crimes committed by the Marcoses is starting to become contentious because of all these losses. So I think that would be a fair observation.
Yeah, I think
Yeah, go
I mean
ahead.
just to add to what Ross pointed out as well, it's something we often overlook when we read about these events, these happenings on the news. It's something that I think we refer to in another publication as epistemological distinctions. How the rulings of the court reflect legal findings. It doesn't necessarily reflect um, truth as a matter of fact, and this is something that I think needs to be brought to the fore. Because if we were to, let's say, base our understanding of Marcos's guilt for what would otherwise be crimes against humanity committed over the period of martial law, one may point out to the fact that, oh, well, he was never convicted. In fact, no one was convicted under for the Marcosian crimes. And if we were to conflate legal finding, legal truth with actual truth, that is the story that will be told. So I think it's very healthy for everyone to keep in mind that legal processes work with different legal standards. If we're trying to convict someone, that's proof beyond reasonable doubt, an incredibly high standard. If we're looking at, and let me refer to another topic which I'm sure Leanne is very much familiar with, which is a PTC determination of authorization of an investigation in the situation in the Philippines, the ICC. That is, on the other hand, a very low threshold of evidence, which is a reasonable basis. So I think we need to keep that in mind. Otherwise, we will set ourselves up for, first of all, confusion when one court
Mhm.
says something happened and another court says it didn't. And well, as a result of that confusion, heartache. We will be disappointed. So I think it's very good that we draw that distinction.
Another topic Lian is familiar with, I would assume.
No doubt, no doubt.
Sabi ko nga, Apa, you went there talaga.
It's right there. I
So,
couldn't ignore it.
for the record lang yun yung sinulat ko kanina, the PCGG has so far recovered 174 billion pesos in Marcos loot, and the items in current litigation involves 125 billion pesos more. At sabi mo nga, Apa, tama yung parang do not conflate legal findings with truth. Kasi naalala ko noong 2019, the Sandigan Bayan dismissed a 200 billion peso civil case against the Marcoses. Pero yung concurring opinion ng isang justice, si Justice Manyalak, sabi niya, it's not really a win for the Marcoses kasi if you probably account for all the Marcos loot, baka yung 200 billion pesos, iba dyan na-recover na natin. So, we might be dismissing this suit, but actually, na-recover na natin yung pera.
Yeah,
And
absolutely.
also, oh yeah. Yeah, sure. Go.
Okay, sorry. Super quick. Yes, and I think the Sandigan Bayan jurisprudence is, in fact, a perfect example for these evidentiary distinctions, standards of evidence that we need to highlight. I mean, another decision, no longer about the Marcoses, but that involving Bong Revilla. It acquitted him, but ordered the return of the funds. So, I mean, it goes to show that a conviction or lack thereof doesn't necessarily mean that money wasn't in fact taken.
In addition to what I mean, going for,
Yes,
aside from ill-gotten wealth, which we are still litigating up until now, it must be remembered that courts have done more than recognizing the corruption under Mr. Marcos. To be clear, it's not just corruption. There are many cases recognizing human rights abuses. For instance, the U.S. court decision in re estate of Marcos human rights litigation states that during the Marcos regime or during Mr. Marcos' time, Filipinos were subjected to arbitrary detention, torture, and summary execution, even going as far as enumerate the methods used for torture. And there are also cases that recognizes the blatant abuse of power under Marcos. In Galman versus Sandigan Bayan, the court said that Mr. Marcos brought the full resources of the government to corrupt and make a mockery of the judicial processes by pressuring judges and prosecutors. So aside from ill-gotten wealth, we have a wealth of cases that legally recognize corruption, human rights abuses, and blatant abuses of power.
Ross, you want to
Yeah.
add something?
Yeah, if I may tie it back to this discussion on ill-gotten wealth, no. If you just look at the legacy of the proceedings that occurred after the fall of the Marcoses from power, the Swiss banking system was actually reformed because of the loopholes and how the Marcoses, exploited certain loopholes in the Swiss banking system. And this is one legacy of the Marcosian plunder that we should also take stock of, aside from all that stated in Supreme Court cases, in jurisprudence outside the Philippines. But also, PCGG is quite a complicated topic because in recent years, grabe yung controversy, no, especially with PCGG leadership. It's an institution that has not been yung track record niya, it has not been that, straight and stellar, kumbaga. I mean, there has been a recovery of the wealth, but the reputational consequences on the PCGG of some corrupt commissioners, it created some sort of cynicism over the institution, and that, I think, fueled the initiative of President Duterte, if you remember, to settle with the Marcoses.
Yeah.
He floated the idea of settling with the Marcoses in relation to the ill-gotten wealth. So I think that is a consequence of how the PCGG moved throughout the post-EDSA political order.
Yeah, and just by reading some of the dismissals by different courts, makikita mo naman na hindi talaga ganun ka-stellar nga ang reputation ng PCGG, especially when it comes to winning these cases. Still on the topic of ill-gotten wealth, sa mga nakikinig at nanonood, Google GR 152154, Republic versus Sandigan Bayan. Ito yung laging kino-quote. This was the decision in 2003 where the Supreme Court declared as ill-gotten wealth $658 million in Swiss deposits and forfeited it in favor of the Republic. So this was a very categorical decision by the Supreme Court. Hindi siya ganun katanda. This was just in 2003. Why do you think denials of corruption still get away? Why do you think pag may nagsabing wala naman talagang ninakaw, may naniniwala pa rin despite this very black and white pronouncement by the highest court of the land?
They're still out there. They're not behind bars. They're free and have actually been on the trajectory of rehabilitating their historical image. And that, I think, plays into how the public perceives that legacy of corruption. No? Na, okay, so what? Sige, meron Republic versus Sandigan Bayan, which I think only lawyers and law students would be very familiar with. Admittedly, before entering law school, I did not know of that case. I know there were Swiss bank accounts. I did not know that there was a ruling from the Supreme Court. And I think that also plays into, the public imagination na wala naman nakulong sa kanila eh. Bakit sinasabi niyong guilty sila of corruption and pagnanakaw when in fact, they're all still free.
Oh, by the way, Imelda Marcos has been convicted of 7 counts of graft pero hindi pa siya nakukulong kasi she can still appeal in the Supreme Court. And courtesy also of the Enrile Doctrine, no, ng humanitarian bill. Jemo, Apoy, do you want to add something to that?
Oh, no, I'm fine. Thank you.
Well,
Okay. Jemo, meron kang sasabihin na napifeel ko. Sige.
parang, the question, as Ross pointed out, does the Philippine educational system properly teach history, or does it just gloss over over one of the country's darkest chapter? I mean, if I remember correctly, when I was in elementary or high school, history books would cover at length the Philippine history from the time of Lapu-Lapu until maybe prior to World War II. And when we go to the Third Republic and when we go to martial law, parang kakaunti na lang yung discussion. Moreover, nowadays, there is also the rise of misinformation, for instance, in social media, which is sadly more readily accessible than accurate statements of history. So included here are those that downplay Marcosian atrocities, while at the same time fabricating accomplishments, which are again, so these types of misinformation are easily accessible. You just have to log on to Facebook. But accurate statements of fact or scholarly discussions of fact are hard to come by. Or sometimes you have to pay for it or pay for access to these kinds of things.
Thank you for bringing up this information. I think the power talaga of this information is the information are packaged in such an understandable and very digestible way. So is it also probably a problem of branding? Like for example, dun sa 174 billion na na-recover ng PCGG, 17.9 I think or 76 has been earmarked for the Coco Levy Trust Fund. Sinong nakakaalam kung ano yung Coco Levy Trust Fund, 'di ba? Could we name it like the Marcos Ill-Gotten Wealth Recovery Trust Fund? Makakatulong ba 'yon sa hindi paglimot sa mga atrocities ng mga Marcos?
Ako, nomenclature matters, no? I agree that nomenclature matters. And it's also a way of mediating social memory. So, ako, the bare minimum for me is to is if we are to come up with a term for this fund, is to always drive home the point that this is stolen money of the Filipino people. Call it whatever you want, ill-gotten wealth, illegally amassed wealth, as long as the fact of it being stolen from the money of the Filipino people remains. I think yun yung crucial na we should never let go of that particular historical and legal fact na indeed ninakaw tong pera na to mula sa kaban ng bayan.
And I mean to add to that, Leon, I think you highlight a really good point, and it's something that is restated in various ways throughout our research paper. How the answer neither begins nor ends with the law. I mean, the law is just a facet of the solution, and if we were to look at Republic v. Sandigan Bayan or any other law or jurisprudence, we think, oh, okay, we won, game over, tapos na. But that isn't the case, because there is a very important process of ensuring that these legal norms are actually translated and inculcated in society. And the fact that we can have a decision which so clearly establishes that the Marcoses and their regime engaged in graft and corruption, yet a few years down the road, again, have these very same names run for powerful seats in the government, goes to show that there remains a gap between the legal decision and its social appreciation.
Habang nagsasalita ka, naiisip ko, sino bang may kasalanan? Yung mga legal reporters ba, aka me? Or is it a collective shortcoming of all of us stakeholders? Moving on, again, in 2013, Pinoy passed RA 10368. Sa website, it was described as an unprecedented legislation both in the Philippines and in Asia. And simply, it created the Human Rights Victims Reparation Board. Medyo malayo yung gap from 1987 to 2013. Again, going back to that question, nakatulong ba yon sa pagpapalaganap ng historical revisionism? Kasi 2013 lang sinabi na we're gonna compensate human rights victims of Marcos and martial law.
I think it played the length of time, the temporal gap between the fall of the dictatorship, at least in terms of Marcos being dislodged from power, and the passage of that law. I think factor yun kung bakit ang tagal on an institutional level, ang tagal bago nakascade yung certain truths and certain beliefs about the Marcos regime. I was teaching this afternoon, just right before this panel, how institutions change. So this is a question I think that relates to that, because institutional change is always incremental, it's always contested, and we can't also put the blame entirely on our policymakers, lawmakers, na bakit 2013 nyo lang pinasa. I could imagine how difficult the road must have been to even have that law proposed in the first place. Knowing that the entire legacy of the Marcoses, their supporters, hindi naman lahat sila instantly nawala from power after 1986. So I could imagine how difficult the road was. And the fact that nagkaroon ng HRVCB is nothing short of a miracle, I think. Yeah, yun.
Yeah, no,
Apa?
that's very much true. That's very much true, Ross. I think there are a number of circumstances that need to align. The stars need to align for the likes of the Victims Claims Board and international mechanisms that we've seen, human rights mechanisms that we've seen domestically, internationally, to come about. I mean, maybe the Human Rights Victims Claims Board, the ad hoc tribunal of the former Yugoslavia, the passage of the Rome. The adoption of the Rome Statute, all of these wasn't simply just, oh, okay, coincidentally, political will is now blowing in this direction. No, there were a number of things that played into these events, and of course, too big an issue for a single conversation. But what I'd like to highlight is this term that I think captures why it would be necessary, why it is very important for these mechanisms to come at the right time and soon after these transitions. It's because they need to find its place, its bearings within what is referred to as a political détente. I mean, at that point in time where it's just floating and the winds of change are going to blow either or one direction. And that needs to be capitalized on. The fact that that wasn't capitalized on as in the late 80s, I think lost momentum, but as through the 90s. But as Ross rightfully points out, the fact that we actually even ever had a human rights victims claims board, albeit later than sooner, is in and of itself a miracle.
Speaking of stars aligning, syempre mas makakatulong din naman if more people know or are fully aware of the atrocities. And RA 10368 provided for the establishment of a memorial / museum / library. So I don't know if end yan or. So do these, tapos sinabi rin that it should be integrated to the curriculum by DepEd and by CHED. So nag-exist ba either of the memorial, museum, and library? Ano tong mga to? Where can people find these museums or libraries? And integrated na ba talaga sa curriculum natin ang martial law education?
This is from an former insider's point of view, Lian, no, answering the question because I was previously connected to the Human Rights Victims Claims Board before its dissolution by law, no, so yung sunset clause. Yung Human Rights Victims Memorial Commission is the one in charge of establishing the museum and now keeping the archives of all the case files, case records of the HRVCB. They have an archive. The museum, the physical museum, as far as I know, it's set to be built in UP Diliman. There was an architectural competition actually a couple of years ago, I think, for the design of the museum, and meron ng winning design. So I think it's in the works yung pag-establish ng physical structure of the museum. I don't know if there are protocols already for access to the archive, but the archive is there and digitized lahat ng case files. So even if may mangyari, sana hindi, pero even if may mangyari doon sa physical files, they're all digitized and they're all, the last time I've heard is may server talaga yan, no? With respect to your question naman on integration in the curriculum, part of the reparations, the non-monetary reparations included in RA 10368 is a memorandum of agreement with DepEd. This was signed siguro a few months before, this was finalized a few months before the sunset clause kicked in. So in terms of implementation, I don't know, I'm not sure how far are we in terms of implementation, but there is an existing memorandum of agreement, not just between the CHR as the agency that would later on implement the HRVVMC, DepEd, I think also other agencies such as TESDA, So, maraming institutions involved regarding integrating martial law education in the curriculum.
Right. So when you say yung case files ay nandyan, I would imagine that if ever the museum becomes a reality, makakakita tayo ng mga parang katulad sa Ho Chi Minh Museum na makikita mo yung pinagdaanan ng mga nabiktima ng atrocities. So when one comes to the when one came to the board earlier on, tapos magki-claim sila, what did they have to prove? Ano ba yung kailangang dinanas nila? Gaano kagrabe ba yung kailangan nilang danasin para maging entitled to reparations, and how much do they usually get?
Okay, this is a bit technical. These are the finer details of the law, no? There was a point system. So 1 being the lowest for minor violations. 10 is the highest for killings and enforced disappearances. 6 to 8 for torture, cruel and inhumane degrading treatment. 9 points also, I think, for sexual abuse. And then, physical injuries. So, bumababa siya, the less severe, kumbaga, the physical injury suffered, no? But of course, there's something to be said about quantifying all these violations into a point system. But that's a discussion for another time. So, this is where the contention lies, no? It's a human rights body. So substantial evidence is ang evidentiary threshold. However, in the Philippines, we don't have laws that state that this is a human rights violation. We always litigate it as common crimes. So you see the disjunct there. You have crimes, common crimes as the basis for the elements, but then your evidentiary threshold is substantive evidence, which is much lower of how you prove a crime. So nagkaroon, again, insider's perspective, nagkaroon ng maraming discussions on the evidentiary, on appreciating the evidence, no? So malaking discussion yan. They also had the issue of presenting primary evidence kasi most of that wasn't documented. Wala tayong documentation process like now we have on the war on drugs. So, yung practices ngayon, malayo sa practices noon. So, masalimuot yung claims process, but as long as you show convincing evidence na naging biktima ka ng human rights violations during Marx's time, may award yan. I think for 1 point, around 175,000. Multiply mo na lang yun, depending on the violation suffered by the person.
So one time to, no? So pag nabigyan ka na, yun na yun.
Yes, and the intake, if I may point out, ended in 2014. So wala nang intake period ngayon. Kung sino yung mga nag-apply up to 2014 or I think 2015 na-extend pa yan eh. So kung sino yung mga nag-apply during that period of time set by the law, sila lang yung pwedeng maging eligible for awards of monetary and non-monetary reparation.
Thanks, Ross. And as expected, yung logistical problem natin, nag-crash yung space. So if you check your DM na, dapat may bagong link. So let's all join again. Sa mga nanonood sa Facebook, wait lang.
Okay. I'm in the Twitter space. Hello.
Let me see. Ito.
Okay, nandito na rin ako. Okay, sa mga nasa space, pasensya na. Ayan, sa mga nasa space, pasensya na, but we're back. Let me just ask a question from Twitter. I think this is a... Thanks, Apa. This is a very interesting question. Sabi ni Lex Delun, I hope I'm pronouncing your handle right. My 9-year-old sister asked me last night what martial law is, and I want to be able to explain it to her, but I don't know where to start. How do you think I should explain it? Anyone?
Actually, I'm glad you asked. I'm glad this question came up because it's a very interesting, novel, and might I say controversial point that we forward in our research paper, Marcosian Atrocities, and it's all in the name. Notice we refer to it as Marcosian Atrocities, not as martial law. And the reason for this is we were wary of what is often, again, the conflation of a societal condemnation and a legal regime. And there is that disconnect. If we say never again to martial law, we are effectively second guessing the constitutional drafters who codified a provision on martial law. Right
Apa,
after,
sorry. I'm sorry to cut you, but you're muted on space, so hindi ka naririnig ng
oh,
mga nakikinig sa space.
oh my, okay, thank you,
Ayan.
thank you.
Go ahead.
All
Go
right.
ahead.
Let me backtrack a bit. Where was I? Yeah, so and I think it's a very interesting point because this is actually something that is novel about our research, but likewise very controversial in that regard because it's as revealed in the title alone. We refer to the abuses as Marcosian atrocities. We do not adopt the oft passage. Never again to martial law. And the reason for that was we were wary of the conflation of a societal condemnation and a legal doctrine. I mean, I can get into Hume's fork, I can get into what is descriptive and what's normative, but our point really is this. Martial law is a legal regime which was codified by no less than the constitutional drafters right after ousting Marcos. So when we say never again to martial law, we overlook that fact that martial law is in fact legal under the
Yeah.
1987 Constitution. And in that way, again, we set ourselves up to lose. We set ourselves up to be disappointed because we come before a court, we say martial law equals this, and that. But in fact, what we mean is what we are condemning or isn't necessarily a legal regime which inherently carries no normative value, but the abuses that were effected through that legal regime. So we need to draw a distinction between martial law as a legal doctrine and martial law as a tool for Marcosian atrocities, martial law carried out in Marcosian fashion. So if I think the question asked about the 9-year-old sister, how to answer that question? Indeed, a very difficult question. I would draw first of all that distinction that martial law is a legal regime, and what we're guarding against is in fact the different ways bad governance turns its ugly face.
So, dapat never again to Marcos martial law.
That's one way we could portray, but I mean, various ways of forwarding it. We condemn Marcosian atrocities in our paper. Never again to martial law in Marcosian fashion might likewise be possible. But in so many words, what we're reminding our readers of the article is to distinguish legal doctrine from societal condemnation.
Anyone else? Oh, you guys teach, diba? Paano pag tinanong kayo ng mga estudyante nyo? Where do you start?
It's a bit difficult, no? Kasi the question asks for a 9-year-old sister. And a 9-year-old, imagine describing all of these things to a 9-year-old kid. But going back, I remember correctly, when we were young, maybe like high school or grade 7, grade 6, networks would usually have a special during about martial law, especially during I think around February for EDSA Revolution, and part of it would be painting the picture what exactly happened during the martial law era. You'll have people being arrested on mere suspicion alone. You'll have people being tortured. You have people being killed. All the while the Marcoses were trying to we're fattening their purses, and all these happen, as Appa pointed out, illegally because of the regime created by Marcos. So I think the way to explain what happened during the Marcosian regime would be just to paint a picture what happened. What were the abuses that were done? Vis-a-vis the misinformation about the greatness allegedly of Marcos. That he built bridges, he built infrastructure, when in fact these things were built to channel foreign debt into as ill-gotten wealth.
Ako, I have a 9-year-old niece, no? she actually has COVID now. So everyone listening, please pray for my niece's full recovery from COVID. And if she's 9 years old, she hasn't asked me yet. I think hindi pa yata to na discuss, or like she's just really really into BTS. So that's also but she hasn't asked me yet. But if she were to ask me today, how would I explain it, no? Explain it in such a way na I wouldn't use siguro because first of all I wasn't there, and that's a usual criticism to younger people like us speaking about martial law. We have now a wealth of resources of victims themselves speaking out on these crimes, and daming interviews with survivors of martial law, and I think that's a good place to it's a good resource to start discussing what kinds of things happen from the perspective of the victims, no? Our encounter with the truth, with historical truth, should always, I think, begin with looking at these lived experiences of people. So I think that's how I would teach my 9-year-old BTS fan niece of how to appreciate martial law.
Which is why I really feel strongly towards building a museum, kasi there's nothing like a museum that you see yung visual, yung nahahawakan mo, and it's just there para ipaliwanag sa'yo kung ano yung mga nangyari nung time na wala ka at hindi ka pa nabubuhay nun. Going back to the discussion, in 2017, maybe a lot of people don't know that President Duterte signed Proclamation number 319 declaring today, September 21, as the National Day of Protest. Tapos dun sa mga whereas niya, the proclamation described martial law as a time attended by the commission of gross human rights violations, arbitrary state interventions, rampant corruption, and disregard of fundamental civil liberties. Big deal ba to na nag-declare ng state of national protest at dinescribe ng ganito ang Marcos martial law?
Well, sorry. Sorry, Jamie, you want to go for it?
Go. I think it's
Oh, yeah, sure.
Go, bro.
Okay, sure. Yeah, I think that we can't discount the fact that this is actually something that is big, something that is very useful, and something that is a feat in and of itself when it comes to remembering the Marcosian atrocities for what they were. But at the same time, it reveals other problems. How easy it is to pay lip service to human rights law. How easy it is to talk the talk but not walk the walk, which is, of course, which reveals a whole other set of problems, which would need to be addressed, not only with how we appreciate these laws and declarations. And I guess I would highlight that as a declaration, PD 319 would be a memory law, as it declares and recognizes it recognizes the fact and the interpretation of that event. But we should realize that just because something is codified in law, again, doesn't necessarily mean that it is recognized in practice. Again, I mean, a very large gap between doctrine and deed. And I think the 27 PD is a great, proclamation is a example of that.
Jemo?
Well, as Appa pointed out, there's a very large gap between practice and this proclamation. So on the one hand, at least we have a proclamation coming from the president stating that martial law is a time attended by the Commission of Gross Human Rights Violations, etc. On the other hand, you have a president generating nostalgia towards authoritarianism, even branding the former dictator as one of his idols or one of his role models. And even, as I think we will discuss later, allowing such person to be buried in the libingan ng mga bayani. So again, while it is a good thing that we've heard such kind of proclamation coming from this president, it's a far cry from the actions of this president.
Thanks, Gemma. Sa Facebook. Sorry, go, Ross.
Yeah, ang madadagdag ko lang dun is this president has actively withdrawn himself from public rituals of commemorations of EDSA. And that's very telling. of how Duterte is trying to shape the narrative in such a way that although there is no public repudiation of the legacy of people power or the legacy of those who fought against the dictatorship, there is deliberate dismissal of the value that this holds for social memory. So Duterte not showing up for public commemorations is very, very telling.
Thanks, Ross. Sa Facebook may nagtatanong about sa memory law. Guys, we'll get there. Isang tanong na lang and we'll get to the memory law. Apa, you said na merong gap yung legal sa live practices. But also, in 2016, when the Supreme Court allowed the hero's burial of Ferdinand Marcos, there was also massive backlash. Kasi parang ang sinabi ng mga kritiko ng decision na yon, parang kinalimutan na, parang inilegitimize yung, 'di ba, yung mga pasakit ng mga human rights victims. So, what are your views on that? You also tackle that in your paper. What was the effect of Ocampo versus Enriquez dito sa legal recognition or judicial recognition of Marcos atrocities?
Yes, I still remember the day that Ocampo came out. Jemo, Ross, and I were in the UP Law Library studying for the preparing for the Philippine bar.
For the bar exam, yeah.
For the bar exam. And once the decision was announced, we packed up our books and left, and it was just totally disinspiring.
No, we went to the smoking area.
Right. Yes, we did.
Yeah. And then it's ranted, yeah.
Yeah, it's very difficult. So of course that's from a more personal perspective, but I'm sure you're asking with regard to the larger implications of Ocampo v. Enriquez. So did it illegitimize previous efforts? I can't say outright, and I wouldn't want to say outright that it illegitimized any of our efforts before. I think we would be shooting ourselves in the foot in so doing. I mean, we still want to recognize the Proclamation 319, the Human Rights Victims Claims Board, as legitimate efforts and standing legal efforts. So I wouldn't go as far as to say that it had that retroactive effect of illegitimizing. But again, it did reveal the perhaps illegitimate or non-legitimate concerns of the Duterte administration, as well as of other branches of the government, particularly the court decided that case. I mean, the irony was clear. We were invoking Rule 60. We were invoking the special jurisdiction of the court, yet the court looked at this case and said, hey, it's a political question, we leave it to the elected officers. When in fact, the Supreme Court is empowered under the 1987 Constitution precisely not to be undone by a political question doctrine. So, I mean, there's so many things to be said about the effect of Ocampo v. Enriquez. It was confusing, for one. It sends mixed signals to the general public as to where this government stands, but we should draw a distinction as to those stances they make when there aren't very real consequences. There is the declarative, there is the Proclamation 319 that declares recognition, and there is this actuation, that resulted in Marcos's burial in the libingan ng mga bayani.
O punta na tayo dun sa proposal niyong memory law. First of all, do you propose it to be a penal law? Meron bang sanction yan? May penal sanction ba yan?
Yes. Sorry, Gemma.
Go ahead. Yes. Well, memory laws, I mean, as Apa pointed out a few minutes ago, memory laws, as we are well aware of the atrocities committed by Nazi Germany during the Second World War, including the genocide or mass murder of Jews and other minorities. So what happened during the latter half of the last century was that there was a growing movement, like what we have in the Philippines, that sought to approve, deny, or downplay these atrocities. So in response to these, several countries, at least I think 18, have such laws that punish the approval, denial, or downplaying of Nazi atrocities. So hindi lang to Germany, no? Including Austria, Belgium, Czech Republic, Greece, Hungary, Israel, Italy, Liechtenstein, Lithuania, etc. So what they do is it's a penal law. It penalizes um, the approval, denial, or downplaying of Nazi atrocities. In Germany's case, it depends. It could be either 5 years imprisonment or 3 years imprisonment. So essentially, according to, under the German law, the approving of, glorifying, or justifying Nazi socialist tyranny or an arbitrary rule incurs a penalty of imprisonment.
So, but penalizing any kind of expression would have massive free speech implications, and you did recognize it in your paper. So, paano? How do you strike the careful balance? Kasi freedom of speech is a very, premium value kahit sa ang demokrasya. So, how do you balance it? You used examples from the Holocaust. Can you explain paano ma-marry yung dalawang yun?
Yes, I think you're definitely asking the right question as to how do we protect the interests of victims of human rights law and of society writ large, while at the same time acknowledging and abiding by the demands of freedom of expression, freedom of speech. And that is what is explored in our paper, the possible legal avenues through which a memory law would need to go through in order to regulate the denial or denialism or revisionism, yet at the same time respect freedom of expression. And we identified a number of possibilities. For example, for the German Constitutional Court, they drew a distinction between fact and opinion, and we are all entitled to our own opinions, but we are not entitled to our false facts. And I recall, and it was in fact something that we quoted in our paper, how Bongbong Marcos, in an interview, said that, oh well, I think my dad didn't commit these. I think the dictator did not commit
Interview in 2018 nung paper
yeah,
nyo,
back in
hindi yung
yes,
recent.
yes, sorry, thank you. Back in 2018, and he mentions that he believes that Ferdinand Marcos in fact did not in fact commit these crimes, and well, we have different opinions. We can agree to disagree, and that conflates again fact from opinion. So, according to the German Constitutional Court approach, Article 5 of the Basic Law affords protections for opinions and not so much for false facts. Now, we likewise acknowledge in our paper how the Bill of Rights of the 1987 Constitution isn't structured the same way. But nonetheless, we have had jurisprudence that have recognized that fact-opinion distinction. So that's one. Another way that we identified justify the possible validity of a memory law that criminalizes is by distinguishing between the exercise of a right and the abuse of right. And jurisprudence is rich with this regard, particularly if we look at the regional jurisprudence of the European Court of Human Rights. It goes by many different names. Perhaps here we refer to it as unprotected speech, fighting words. But it's a very interesting game of characterization where what would appear as an expression by one will be recharacterized as an action. This isn't prejudicial speech, this is prejudice, full stop. And thereby removing the protection of freedom of expression and treating it as conduct instead. So there are a number of different avenues, but we have identified how a memory law, though undeniably contentious, may be constitutional under Philippine legal order.
And it bears reminding, no, that not all kinds of expression are protected by the right to freedom of expression. That our constitution, our case law specifically tells us that there are kinds of expression which are not protected by the right to freedom of expression, and even from the perspective of international human rights law, it's always a balance between the speaker's right to speak and the rights of the subject of such an expression. And in these types of cases, when it comes to denying the atrocities committed against its victims, according to certain jurisdictions, it actually amounts to hate speech because it vilifies and denies their experiences during these periods of history. So as a balance, the deny fine you're entitled to your opinion, but you are not entitled to deny certain facts which are not only historically proven, but are actually legally recognized.
Thanks, Gemma. We have a question from Facebook. Si Ash Presto nagtanong. I'll just shorten it. Yung memory law ba na pinopropose nyo, is it only on institutions and powerful people and groups? Because how would you, ano daw, parang paano nyo ibabalance? For example, if a person, an ordinary person, her lived experience of martial law was, it was beneficial to her. So, nakinabang siya in whatever personal capacity. So, who does sinong i-cover ng proposed memory law nyo?
Well, perhaps we should highlight at the outset as well that the academic article that we've published identifies the legal nuances. It isn't a draft bill that actually proposes that law per se. Rather, it identifies the legal obstacles that will need to be hurdled if a memory law were to be adopted or were to be passed by the legislature. And the question that Ash poses is at the center of laws that regulate hate speech, incitement to violence, and the like. And one very useful tool that I would invite everyone to look at is what is referred to as the Rabat principles, which looks at discrimination, albeit not necessarily political stances. But what it does recognize is that distinctions need to be drawn not only based on the speech per se, even though that's what we see in the Auschwitz lie case, but outside of that very special context, Germany itself prohibiting, with that history tightly entwined with Nazi Germany as well for obvious reasons. We would need to take into consideration a number of factors, such as the speaker, the context, the platform, the extent, and of course, the possibility or imminence of violence. So there are a number of considerations other than the content of the speech per se that must be taken into consideration when deciding on whether or not we should prohibit or otherwise criminalize denialism or revisionism.
Just to add to Appa's point, very briefly, and hi sa nagtanong kay Ash Presto. Hello. In criminal laws, in legislating penal laws specifically, we have the principle of legality, which tells us that there has to be a certainty as to who will be punished, what will be punished. And I think this is also the problem with, and exactly the reason why we're challenging the anti-terror law right now, because there's a great deal of uncertainty as to what speech is considered incitement. So, as Appa has said, there has to be parameters. There has to be little discretion as possible when implementing such a law in the future, no?
At talagang you went there din sa anti-terror law. Okay, just to, in an attempt to laymanize this further, if I am a Marcos supporter and I really do believe that they really didn't do anything bad, how can I still express my opinion if a memory law were to be passed? Or can I still express my opinion? Can I still vlog? Can I still tweet adorations of Marcos and the martial law era?
Well, again, that is the contention. That is the contentious area, and it would largely depend on the legal parameters, the legal nuances, and the way the law is defined. If a law goes as far as the German law that prohibits all forms of denialism and revisionism, then they would need to justify that. We would need to justify that based on our particular context. So, adopting their approach, the legislative or the lawyer who's before the Supreme Court trying to defend the validity, the constitutionality of a memory law prohibiting all forms of denialism or negationism would need to jump through hoops, would need to qualify what was said not simply as bad speech, but as an abuse of right. And this was this very same approach that was adopted before the GCC, as well as the European Court of Human Rights, which portrayed the denial of the Holocaust either as hate speech, as an attack on others, and likewise as re victimization. To deny that it ever happened were to have the victims undergo pain anew. And if these justifications are convincingly forwarded, then that would mean that under such a strict law, any form of expression would be prohibited. However, a more tempered law would again acknowledge particular parameters rather than a blanket prohibition or a blanket criminalization of denialism and revisionism. We could take into consideration particular elements. Such as intent, such as whether what is being expressed is genuinely held or is being forwarded as an academic opinion. So these elements would soften the blow of a memory law on freedom of expression. But we have identified in our paper that should a law as prohibitive as that we've seen in the Holocaust, in the Auschwitz-Lie case, then it may actually pass constitutional muster. And I guess I should likewise highlight, and this is something that we've highlighted in the paper, is that this isn't a potentiality. This isn't in abstract terms. In fact, if we look at the revised penal code as it stands, it does prohibit publications of false news to an extent through, I'd like to say, Article 156, if I'm not mistaken. So whether this law may be used to prohibit historical revisionism, negationism, denialism, based on the elements of crimes, I say it may, but we've yet to see it used in that way before the court of law.
Sabi mo
Just
nga, Apa, the stars... sorry, Gemma, go ahead.
just note, no, we could go strict, as Apa pointed out, na all kinds of glorification or adoration of atrocities could be prohibited. But on the other hand, we could go on a softer side, like other countries do. Some countries specifically include terms like whoever publicly disturbs public peace by such methods may be imprisoned, blah blah blah. So it's up to Congress. But as Apa pointed out, what we demonstrated in the paper that we wrote is that these kinds of laws about prohibiting the denial of atrocities could be constitutional, could pass, as Apa pointed out, could pass constitutional muster.
Yes, Ross, you were gonna say ba something? Apa, sabi mo kanina, the stars have to align para sa yung journey na binagtas ng lahat ng to. The stars had to align. Do you think the stars are aligned for a memory law?
No.
No.
Yeah, no, I think we would need to set the stage for a memory law. And this is why we emphasize through our paper as well that societal aspect about bridging legal norms and social mores, because neither will things be solved by passing a law, passing a memory law, much in the same way that things weren't solved by passing a new constitution. We would need to inculcate, we would need to appreciate, we would need to affiliate the Marcosian atrocities where it's with its moral deprivation. And by so doing, perhaps we would set the stage for a society that will not only follow a memory law, but would in fact accept it. Of course, the goal is to have a society that wouldn't need it, but unfortunately, that doesn't appear to be the case.
There's a comment on... on Twitter. Sorry, there's a comment on Twitter. I think this is a reaction to Gemo from Job. Hi, Job. Sabi niya, if you temper the parameters of a proposed memory law, doesn't that impair one of the possible aims of a memory law, which is to set or keep the record straight on martial law?
Well, it depends on. It would depend on the intent of whoever would frame the memory law. What we've done is to provide examples of memory laws, and how this could be done. Each country or each jurisdiction would have their specific needs, would have their specific limitations. For certain countries, they could go as strict as possible because they need it, or because the laws allow for it. In certain countries, it has to be tempered because again there are specific legal limitations, or because context require otherwise. So it would really depend on the intent of the framers and whoever would draft such memory law in the Philippines.
Ross, I cut you off kanina. You were gonna
Oh,
say
yeah.
something.
Yeah, I was gonna jump off of Appa's point na he said there has to be a parallelism between the social commitment to remember and to reject what he said, the moral depravity of the Marcosian atrocities. If I may add to that, we also have to consider on the level of accountability, the level of accountability and the level of consequences happening to people who actually committed and perpetrated these injustices. Because as we have discussed earlier in this panel, no, much of the contested nature of these discussions today stem from the fact that there has been no long lasting accountability and consequence for the perpetrators of injustice during the regime of Ferdinand Marcos. So I think one way to foster a social milieu that is receptive of remembering and honoring the victims of Marcosian atrocities is to make the perpetrators accountable.
Walang nasabi. How do we do that? Okay, lastly, on the last point, you wrote in your paper, the Philippine memory law must thus be facilitated by political will and social attitudes to mean something. This would be a wrap up of 1 hour worth of panel. Who wants to go first?
Uh,
How do you make political will? How do you facilitate or create or pave the way for political will and social attitude for all of this to mean something?
Well, if I may, and I think Ross, Jemo, and I pursue this. I mean, we're all lawyers, but we're also academics. That's precisely why we've written this paper. It's because we recognize the value of courtroom advocacy, but we also recognize that very unique change of classroom teaching. And I think in many ways, education is that key. It's one thing to transplant a rule, it's another thing to allow these realizations to be organic, that students, rather than being threatened with a penalty, would be, rather than be at the end of a gun, have a book in hand. And I think that would spell the difference, that would set the stage for perhaps the legitimacy of a memory law, and, well, ideally, the lack for a need of a memory law.
I'd
Ano?
echo the same thing. It's one thing to know that something is prohibited. It's one thing to know that you can't glorify a mass murderer for all the atrocities he has committed. But it's another thing to know why you shouldn't be doing that in the first place. It's another thing to know the effect on the victims, and it's another thing to know what allowed for the rise of such a dictator, and what allowed him to have free reign to steal money from the public purse, to corrupt government officials, and to subject thousands of Filipinos to torture, arbitrary detention, and extrajudicial killings.
Ross?
Ako, siguro, I've written this elsewhere in another study on the mechanisms naman. No? Said something like, the ghost of Marcosian atrocities persists to this day. And it's time that we make a commitment to do away with the persistent ghost of this legacy by introducing, as I've said a while ago, accountability, for the perpetrators to be brought to justice, even in this late in the game, any form of justice, and centering the narrative again on the victims and their experiences, and their heroism during martial law.
All right. Thank you so much with that. That was 1 hour and 10 minutes. Sorry, Gemma, kung inaantok ka na. But I think we had a lot of listeners on Twitter Space and a daming comments sa Facebook. But we can read them all. Thank you so much again, guys. That has been Attorney Ros Togade, Attorney Apa Pangalangan, Attorney Gemma Fernandez, all proudly products of UP Law, and the authors of the paper Marcosian Atrocities, Historical Revisionism, and the Legal Concerns on Forgetting. Guys, is this publicly available online? Pwede ba nalang mag-Google to?
I think my again we're going back to the issue of access and paywalls, no, but they can message any of us siguro on Twitter. We can
Yes.
provide access if they so need, if they need it for research, for to inform themselves. It can be made available to them.
Kumbaga, slide into their DMs na lang if you want a copy of that paper. Thank you so much. This was a special episode of the Law of the Tertaland podcast. I am Lian Buan and register to vote. Thank you.
Thank you, Leanne.